Lordship, I beg to mention item number 25. I'm appearing for all the three respondents hearing, respondent number 1, 2, and 3. Lordship, I'm seeking 3 weeks' time for filing the affidavit in opposition for all the three respondents.
Learned counsel for the respondents. Respond and is granted.
For all the 3 weeks' time.
3 weeks' time to file affidavit in opposition.
Highly obliged.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 19.
Yes.
In this matter, I may bring for respondent number 1 to 5. Lordship, the 3 weeks' time may kindly be granted to me, Your Lordship.
Okay.
Your Lordship, in the meantime, interim partial may be continued.
Interim order partial days.
Obliged.
Deeply obliged, my lord.
May I please, my lord. Lordship, item number 12. Lordship, can you grant me 3 weeks' time to file affidavit in opposition?
Respondents, all the respondents.
Yes, for state respondents, Lordship.
State respondents.
Lordship,
May I please?
I beg to mention motion item number 33 and 34. Lordship, I'm making a mention on behalf of learned counsel Eleville. So I'm informed that both him and his junior are unwell. So if this matter be listed on Tuesday,
33 and 34.
33 and 34.
Tuesday.
Tuesday, Lordship. This Tuesday. Tuesday.
Thursday.
May it please, Your Lordship.
Holiday. Thursday is the holiday here.
Whichever day, Lordship can.
Okay.
Maybe on Friday. Friday is also holiday. 15. 15 maybe, I think. For next week, next Monday.
Okay.
Monday.
Which date? Tell us the date.
15.
15th. Okay.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 29 for hearing, Your Lordship.
29.
Your Lordship. Your Lordship, here I'm appearing for respondent 2 and 3, Your Lordship. Your Lordship, I pray that the matter be posted on 15, Your Lordship.
15th.
Okay.
29.
29.
Yes. Yes, Mr. Sala.
My lord, I have the item number 32, my lord, motion.
Muson. Okay.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 5, Lordship.
Item number 5.
Lordship, if 3 weeks may be granted to file my counter, Lordship.
When?
3 weeks, Lordship.
2 weeks to file affidavit.
Lordship.
Item number 5. Yes.
Lordship, I have similar prayer for item number 38, Lordship.
38.
Lordship.
Okay. 38 was state respondents.
Lordship, similar prayer for item number 7, Lordship, on behalf of Muslim, Lordship.
7.
7.
On behalf of government.
Lordship.
Yes.
And Lordship, item number 11, Lordship, on behalf of TIPA.
Item number 11.
Lordship.
For affidavit in opposition.
Lordship. Obliged, Lordship.
May I please, Your Lordship? May we please to mention admission item number 4, Your Lordship. Your Lordship, it's under preparation, Your Lordship. However, there's some clarification.
4, somebody made a mention, I think. Item number 4? No. No, okay. 4.
Your Lordship, 3 weeks for affidavit.
3 weeks
Yes, Your Lordship.
for affidavit.
Your Lordship, item 6 also, Your Lordship, same.
Okay.
And item 9. I'm
Item
yet to
9.
receive instruction, Your Lordship.
All affidavit in
3 weeks.
opposition on behalf of the state respondents.
Much obliged.
Any interim order, if anywhere, just tell us.
Much obliged.
May it please your lordship, I beg to mention item 27 and 28.
27 and
28.
yes,
Your lordship, on the consensus of the parties, let this matter come up for hearing on 8
8
April. Yes,
8 of
April.
8 of April.
Please, Lordship, Lordship, I beg to mention item 26.
26.
Yes, Lordship, this is a part-heard matter by Justice Budi Habun. So,
Okay, he's coming next.
yes, so Lordship, fix it on 15th of April.
15th.
Yes, Lordship. Much.
Huh?
Item 26.
What to do on 15th? Okay.
May please your lordship. Lordship, I beg to mention item number 14.
4
14.
1 4.
Yes, sir.
Yes.
Your lordship, 2 weeks time may be granted to us to file our position.
Lordship, here there is urgency in this case, Lordship. They have already served time once, Lordship. I am here praying for cancellation of the bail
You
that
have
was
come.
granted to them, Lordship.
Okay. Is
Now,
it-
I am the elder brother of the deceased person.
mm.
And bail was granted on extraneous reasons.
okay. You are for the petitioner
Yes, I am for the
for
petition.
cancellation of bail. You are
Yes.
for whom?
For private respondent.
Private respondent. What about the PP? We need the case diary to look into.
Lordship.
Isn't it?
Yes, Lordship.
So if bail is granted, you are objecting.
Yes.
Now we'll have to have the case diary.
Lordship. It may be
Whether
called-
where is the PP? If case diary is there, we can fix a date immediately. Wait for some time then. If
Okay.
since object, wait for some time.
Lordship.
Let the PP come, inform the PP.
Your lordship, for item number 18 as well.
Item number 18.
Yeah, 3 weeks time may be granted.
You are for
For the petitioners, for all the petitioners,
petitioners. 3 weeks to do what?
to file a reply.
Reply by petitioners. Huh?
Much obliged.
Lordship, in item 18, my name will be reflected. I am representing respondents 1, 2, and 3.
Registry to item heredity. Huh?
No, Lordship, it is reflected in the cause list, but in the order, in today's order, if my name can kindly be reflected.
Okay, okay. Mr.
Sendianga.
Is present, Sentianga is present, representing the respondent number
1, 2, and 3.
1, 2, and 3.
Deeply authorized.
May it pleases your lordship. Lordship, may it pleases your lordship.
Yes.
Lordship, I beg to mention item number 15 and 16. I am for the appellant. Lordship, I apologize. As per the earlier order, I could not take the steps. So I may be granted 3 weeks time to take steps, my lord.
Learned counsel for the petitioner press for and is granted to take steps in terms of this court's order dated.
Okay, earlier dated, my lord. I have to,
Silo bolas.
my lord, may I pray for fixing a date, my lord? Any date, my lord, as per your lordship wish.
No, no,
Convenience.
no. This is to go. It is to return. Give a date after 6 weeks.
My lord, any date.
Give a date after 6 weeks.
Please, your lordship. Lordship, I beg to mention item number 30, your lordship.
30.
Yes, lordship. On behalf of my senior officer of your lordship, who has difficulties today, your lordship. So I present this matter, maybe.
22nd of May. Item 38. Yes.
30, yes, lordship. So, lordship, I
Something
present
Obliged.
mentioned already.
30.
30.
Yes, lordship. 30.
Okay.
So I present this matter may come up on Friday, lordship, this week, Friday.
Why?
Lordship, my senior historian is not keeping well
Okay.
today.
On the prayer of the learned counsel for the petitioner,
Respondent,
respondent number 3, matter stands adjourned and be listed on Friday.
okay. Deeply obliged, my lord.
Yes. From the supplementary cost list for motion item number 32.
Yes.
Yes.
This is the application under 482, my lord, for passing of information, which is started GD entry only. My lord, we have made payments, my lord, for supply of goods but they fail to supply full goods, my lord, for which we have to file a commercial suit, my lord, in Jorhat. But they filed my lord, information at page 22, my lord. If you also see, this is a civil dispute, my lord. I want to state that Rexona only had purchased Masoor Dal Chana to my company of 20 lakhs and paid rupees 8 lakhs in advance and kept rupees 12 lakh in credit.
G. N. Sayola, learned senior counsel, assisted by
D. Deca.
E. Deca, learned counsel. The present petition under section 482 is filed assailing and first
GD entry, my lord.
it is GD entry. No FIR is registered.
No FIR registered, my lord. If you also go to page 32, my lord, 41 a notice has been issued. When we appeared, we have threatened that we pay the amount, otherwise we will arrest. Page 32.
Assailing criminal proceeding.
Reference suburban, yes, GD entry,
Proceeding on the basis of a complaint filed by the respondent number.
number 1, 2.
Respondent number 2. Respondent number 2. Primarily on the ground that the investigating authority could not have initiated a criminal proceeding by recording a GD entry, inasmuch as, according to the learned senior counsel, no cognizable offence is made out and the matter is purely civil in nature. In this regard, Mr. Sayola further contends this. Already a suit has been filed?
Yes, my lord. That is at page 29, my lord.
Already a suit has been filed by the petitioner at Jorhat, and the present FIR has been filed to as a counterblast to the aforesaid civil proceeding. Full stop. Issue notice returnable after give a date. When, Mr. Sayola?
Any day, my lord. May, my lord, it may be.
May, after 6 weeks, May give a date. 22nd of May 2024. Considering the nature of allegation made in the FIR dated,
my lord, 27-3.
20?
7-3.
No.
No, 7-3 to
7/3/2023. 7/3/2023 by the respondent number 2 before the officer in charge suburban police station.
GD entry number 8 of 23, my lord.
Within bracket GD entry number
8 of 23.
8 of 2023. Comma, it is provided that no further investigation shall be carried out in terms of the aforesaid FIR.
For motion, item numbers 35 and 36. May I please, Your Lordship?
What is this?
My Lordship, by this instance, civil revision petition, I'm challenging the impugn order dated 15/11/2023 passed by the learned district judge Mon in civil appeal 2 of 2022.
Where is that order?
Lordship, can you come to page 262 and extra 20? Yes, Lordship.
Correct order. Appeal was against which order?
Appeal was against the EAC order. Lordship, the history of the case, Lordship.
Whatsoever history, Deputy Governor, the district sensation judge will not have any jurisdiction.
Yes, Lordship. Lordship, my prayer was not just the EAC order, but my prayer was also to comply to the order. Plus,
Where is the jurisdiction? Under what provision upon district judge? Any decision taken on the matter referred? Already I have passed a judgment sitting here holding that no jurisdiction and referred the matter to a larger bench. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed. It is one option. Another option is dismissed.
Lordship, in that case, if my senior may be given.
Because see, I have already passed the region orders, Kabisati Sesa. That is a reported judgment. So I cannot change my views.
Lordship, just for the satisfaction of my senior, Lordship. Lordship, just for the satisfaction of my senior. If,
no problem. We'll adjourn it.
Madam may be listed after the regular items.
Okay.
Okay, Lordship, maybe.
He's giving a good advice.
Lordship, a day may be fixed, Lordship.
Okay. Let the date be on 15th.
15th.
Or 15th.
For admission item number 1.
Lordship, on 11/3/2024, my junior has made a mention about filing up some application in the civil court for deletion of the names of the present petitioner. Once that case is decided, this matter will automatically become infructuous. And I have an instructions that the case is fixed on 3rd of May. So this matter may be listed thereafter. Say, so 6 weeks time may be given, Lordship.
Your Lordship, I've been instructed by my senior on behalf of the respondent numbers 1 and 2 to simply mention, Your Lordship, that the revision petition, Your Lordship, it should be dismissed because at this stage, Your Lordship, nothing survives. In the previous instances, the court is pleased to note that there is no ground for invoking the revision jurisdiction, and the prayer for the interim order has also been rejected. So nothing survives, Your Lordship, and they've already filed, like learned senior counsel has said, they've already filed an IA in the lower court to strike off their names, which was one of the.
Have you filed it?
Yeah, we're yet to file an objection.
So there is a order on 11/3 saying that petitioner is going to file an IA.
Yes, in the lower court.
In the lower court.
Yes.
So moment IA is filed, it is deleted. He will have no cause of action.
Yes.
So this revision petition will go. Because in no order will affect the petitioner.
Yes.
No order will affect them.
Yes.
Now therefore, whether that IA is filed.
That has been filed and it is fixed on 3rd of May.
Okay.
That is why let it be listed thereafter.
Otherwise, there is no stay order, nothing is there.
Yes.
Okay. It is submitted by the learned counsel for the parties that IA has already been filed before the civil court. IA, as reflected in order dated 11/3/2024, passed by this court, has already been filed before the learned trial court, and matter is fixed on 3rd of May. In that view of the matter, both matter stands in such view of the matter, the revision petition stands adjourned and be listed in a 2nd week of May.
Lordship. And there is another petition which is not listed today. That is civil revision 17 of 2023.
List this matter along with civil revision petition
17 of 2023.
17 of 2023.
17 is not listed, so it should be listed along with 16.
That's why I'm saying it should be listed along with this.
Yes.
That should be listed along with this.
Obliged.
For admission, item number 2.
Same thing, Lord.
Same thing.
Yes. And there is another case which is not listed today, that is civil revision 17 of 2023.
Along with.
Yes.
So,
These three should be listed together.
again, list this matter, list this matter along with civil revision 16 of 2023.
16 and 17 of 2023, which is not listed today.
17 is not listed.
Yes.
16 and 18 is listed.
Yes, Lordship.
For admission, item number 3.
Please, Your Lordship,
Hmm.
on behalf of Ms. Morning,
Okay.
he's yet to receive instructions. So may I pray that 3 weeks' time may be granted, Your Lordship.
Lordship, it's a long pending matter and 3 weeks why to file. If they have got the instruction, it won't take 3 weeks, Lordship.
Now
We are yet to receive instructions, Your Lordship.
yet to receive
So
instruction.
Lordship, kindly peruse the
4-3.
previous order on
4-3.
4-3,
I've
yes,
seen
Lordship. Then basing upon the effect of the petitioner's case, the matter may be disposed of, listed for hearing on Thursday, Lordship, or next week, any date, so that it can be disposed of.
See, there is an order of personal presence before the Advocate General Office. I think you have got instruction.
Yes, that is what I was informed, that he has got instruction.
My Lord,
So
my learned friend, he is attending court number 1.
That's why.
And he prays for 3 weeks' time.
Okay, we are fixing it week commencing from 15th, any date?
Yes, ma'am.
Huh?
Yes, ma'am.
Because in the meantime, there are holidays and all.
Yes.
Huh?
Yes, ma'am.
Okay. Madam, just tell us, give us a date.
Then, yeah. On 16th, Lordship.
16th?
Lordship.
Okay. On the prayer of the learned council, state council, matter stands adjourned and be listed on 16th
That's
of
admission hearing.
16th
Of April.
Swencher for admission hearing. In the meantime, the respondent state should invariably file their affidavit.
Obliged, Lordship.
For admission, item number 8.
Yeah, this is Lordship.
Yes.
Lordship, I beg to mention on behalf of S. Mary Edge,
Okay.
Lordship. Plan 3 weeks time, Lordship.
Okay. Learned state council prays for and is granted 2 weeks time to file counter affidavit.
3 weeks time.
3 weeks time. The interim order passed earlier shall continue till the next date of listing.
Obliged.
Obliged, Lord.
For admission, item number 10.
There is also no counter.
My Lord, I may be granted 3 weeks' time.
3 weeks.
Lordship, by last order, so they've asked for 3 weeks' time.
Hmm.
Kindly
We are
pass
yet to receive
appropriate or
instructions.
pass proper order.
Yes, the learned counsel for the respondent state prays for 3 weeks further time. However, full stop. Earlier also the state respondents were granted time to file affidavit. The matters pertains to payment of family pension,
Yes, regularization.
regularization and pension.
Yes.
Because your husband expired
No,
without regulation.
by the order dated 25/2/2019,
Uh,
issued by the Engineer-in-Chief, Works PWD Housing, the Engineer-in-Chief has already regularized the service of the petitioner. But PNR is
but petitioner is not the service holder.
No,
She's
Lordship.
the wife,
Yes,
wife
yes,
of
yes.
the employee
Yes, Lordship.
whose service was not properly regularized. That's why,
Yes.
is that it?
Yes, and the government was supposed to bring instructions on this order.
Ultimately involves payment of family pension to the petitioner. Therefore, 10 days time is granted. And the state respondent should file affidavit invariably by the next date fixed. List accordingly.
Like,
For admission, item number 13.
Yeah, this Lordship.
Yes.
Lordship, I beg to mention on behalf of Avitali Lordship, if 3 weeks' time may be granted Lordship.
All 3 weeks, okay. As a learned state council pressed for and is granted 3 weeks time to file affidavit in opposition.
Obliged, Lordship.
List accordingly.
For admission, item number 14.
Lordship, if the CD can be called.
This is what is a criminal petition?
For cancellation of bail, Lordship.
That matter?
Yes.
Cancellation of
Yes,
it.
Lordship.
Where is the other response?
The PP,
The present application is filed for cancellation of bail granted to the respondent number
226.
in connection with which case number? Where is the order? Where is the order?
The order, Lordship, is
Grant of bail.
86.
at page 86,
26.
annexure 29.
Page 26.
86.
86. Okay.
Yes, Lordship.
কি করলো? Is in connection with what is this? East PS case number.
Yes.
Dimapur East or East.
Yes, Dimapur is PS.
Dimapur East PS case number 292 of 2023, registered under section 302/323/325/34 IPC. Full stop. The bail was granted to the petitioner under section 439 CRPC by the learned principal session judge Dimapur, Nagaland, under its order dated 21/12/2023, passed in IA within bracket bail number 755.
The order is dated 22/12/2023.
Yes, 22/12/2023. In IA within bracket bail number 755 of 2023. Okay. What is the status? Search sheet file or not? Learned additional for proper appreciation of the present petition, the case diary in connection with Dimapur ESP's case number 292 of 2023 be produced on the next date.
On behalf of the respondent numbers 2 to 6, we would kindly request 2 weeks' time to file our objection as well.
Okay, file in the meantime we are fixing. In the meantime, the respondent number
2 to 6.
226 may file their response to the petition. Response in the petition. Yes.
Lordship, on the next date, with or without the affidavits, the matter may be taken.
Because we'll have to see the case diary. What is their affidavit?
Yes, Lordship.
Ultimately, we'll have to decide whether it was rightly given or not
Lordship.
given, and within the parameter. What is that? There is no meaning of any affidavit.
Yes, exactly, Lordship.
Isn't it?
Yes,
List
is
this
right.
matter on. Give a date after 2 weeks. You produce the case diary.
My lord.
18th of April 2020.
Deeply obliged.
For orders, item number 17.
May I please, Your Lordship?
Yes, respondent number 2 and 3.
Yes, I will service report, Your Lordship.
Take fresh steps. Because it was on 13/12/2023. In view of office note dated 13/12/2023. Is there any Lajima code here so that we can verify? Who verifies this status of CA? This is 13/2/12. Return service report awaited. Service report may come in the meantime, isn't it? Because it is in 2000. What is this? 8/3/24. What is 8/3/24? Order. Or court's order, no? So what is in the 8/3? Let us see. Into the learned counsel for the appellant prays for and is granted to take fresh steps in view of office note dated 13/12/2023. Steps be taken within a period of
4 weeks, Your Lordship.
within a period of 10 days from within a period of 2 weeks from today. Take steps, fresh steps, then we'll see. Steps to be taken both ways.
For orders, item numbers 20 and 21.
May I please, Your Lordship?
Yes.
Lordship, the subject of the matter case is that while the state government has taken the property of the petitioners, Lordship, they have not followed the proper procedure of law, and that's why they, under other occasion, they were directed to file their affidavit. Lordship.
Yes.
Lordship, yes, I'm for respondent number 2 to 9, Lordship. Lordship, I'm allowed to file affidavit within 3 weeks' time, Lordship. So, Lordship, please to grant.
But what about the other respondents 2 to 9?
Lordship.
All respondents are duly represented?
Yes,
No,
Lordship.
Lordship,
So the private respondent, the service report is awaited as per the
Lordship.
registrar's report.
Await service report in respect of
Respondent
numbers?
9.
Huh?
No,
9.
Lordship.
9,
Lordship,
item 9, respondent number 9 in petition number 3 to 1, and respondent number 10 in.
Okay. Okay, it was 9 with the 10. How much time do you need?
3 weeks' time, Lordship.
3 weeks.
Lordship.
The learned state council has prayed for 3 weeks' time to file affidavit in opposition.
Lordship.
Lordship, last chance may be given because already my property is acquired.
Prayer is allowed. Since the matters pertains to land acquisition, and it is the allegation of the petitioner that private land belonging to the petitioner has been taken without following the due procedure under Extent Land Acquisition Act, let the affidavit be invariably filed by the next date fixed. Please this matter on. Do you need any date or after 3 weeks?
After 3 weeks.
After 3 weeks. List according.
Date may be fixed.
That's why I was asking, do you want the date? 25th. Give a date in the first week of May so that they can you file it.
First week.
2nd of May
Not.
is a working day. What 6th?
Okay.
For orders, item number 22.
Please, Your Lordship.
Yes.
Your Lordship, by this Honorable Court order dated 11/3/2024,
Mm.
I was instructed to issue notice to the complainant,
Mm.
respondent number 2, through registered post with AD, and I've done that on
Okay.
12.
Notice upon respondent number 2 was issued on 12/3/2024.
Lordship.
Await service report. List this matter May. After 12th of May.
Lordship, if a shorter date can be given because stay
Notice is yes. Okay. Give a date. Give a date. Propose a date from your side.
Lordship, after 3 weeks,
Give a date. Tell us that after 3 weeks.
on the 2nd of May. How about 16th April? 16th April, not May.
16 April.
April. That is after
16
2 weeks.
April with an update. Release this matter on 16th of April with an updated service report.
Obliged, Lordship.
For orders, item number 23.
May I please, Your Lordship?
Yes.
My lord, on the last occasion, a direction was issued to issue notice upon the private respondents.
Mm.
So on the basis of the court's order, we have taken steps.
Okay.
Yes.
6/3. 2 days. What to do? Await service report in respect of respondent number 2 and list this matter on 16th of April.
My lord, I have a humble prayer
Mm.
because here the criminal complaint,
Mm.
we are praying for quashing of this criminal complaint.
Mm.
So if the criminal complaint is stayed, the proceeding of the criminal complaint is stayed.
Let us see on the next date. Huh?
Yes, my lord.
Because on the first occasion, court has not passed it.
Yes, my lord.
Okay, list on 16/4/2024 with an updated service report. Interim order, interim prayer shall be considered on the next said date.
Much obliged.
For orders, item number 24.
Yes.
Yeah, please, Your Lordship.
Mm.
Lordship, I beg to mention on behalf of Pichano Lordship,
Mm.
if 3 weeks' time may be granted.
Who is for respondent number 5? Anybody enters appearance? There was an office note, Wakalatnama has been filed and it was deleted.
Oh,
It was
okay.
removed. Await service report in respect of respondent number 5 and list this matter. Give a date or after list this matter after 2 weeks with an updated
weeks,
service report. In the meantime, the state respondent shall file their affidavit.
Lordship, 3 weeks.
3 weeks. Okay,
Lordship.
give it 3 weeks.
Obliged, Lordship.
From the supplementary cost list for admission, item number 37.
Huh? Where is the state? We want to hear the state today.
He was present here earlier, Your Lordship.
Yes. Let the other, we'll call the other matter. There is, yes, she's there. Who was there in? Yes, yes. Yes, madam, tell us, what is your case? Continuation.
There was no
Continuation,
break
no
in the
break.
service.
You say that
after
their
petition.
salary has also been paid.
Yes,
This is your case.
yes, Your
Now, suppose in case of pension,
yes, Your Lordship.
qualifying service of pension,
Lordship.
what is the principle followed?
Lordship,
Because
I don't
there
have
might
the,
be a correlation between this and that.
But Your Lordship, the pension is not an issue here, Your Lordship.
No, no, it's not an issue.
Yes, Your Lordship.
We'll have to determine its continuation and non-continuation, whether that will affect a pensionable right. The way you are saying, then if we say that the entry into the service, if we go in your favor,
Lordship.
then in case of pensionable service,
Lordship.
qualifying pensionable service,
Lordship.
what will happen then? Because ultimately we are laying down a proposition.
Lordship, Lordship.
Whether if that is made applicable in such manner, then the persons who enter into the service on casual and
Lordship.
continues shall
Lordship.
be entitled for the, that should be counted for the period of
Yes,
qualifying
yes.
service in case of pension.
Yes, yes.
Because that might have an impact upon the state.
Lordship.
You are fighting an issue with an individual.
Lordship.
But if we go by your contention, that
Lordship.
may have a impact upon all the persons who are contractual whatsoever
Your Lordship.
claiming pension.
Lordship, once the computation is done, Your Lordship, then
So
there won't be-
suppose we say the computation taken for the purpose of superannuation
Lordship,
from the date of such and such date,
Lordship,
then that date is to be considered for pension.
Lordship,
Those where there is no dispute of the dispute as the other cases
Lordship,
relating to the pension, then also that qualifying period is to be taken.
Lordship.
Then there may be a serious impact upon the state.
Your Lordship.
Think
I
about it.
understand. Your
Are you
Lordship.
getting my point?
Yes, yes, Your Lordship.
Because we will have to, if we hold in your favor
Lordship.
and dismiss his petition,
Lordship.
then we will have to hold that even if there is a break, but it is a continuation.
Lordship.
And therefore his entry into the service
Lordship.
will be counted from the date he initially entered as a casual or master.
Yes, Your Lordship.
So if that moment we hold that, in all cases that will be the law.
Your Lordship, here there is no break. That's what we are.
No, this is, forget about this case.
Lordship.
Principle of law.
Lordship.
We are holding that entry into the service will be from the date of his initial appointment.
Yes, yes.
Maybe casual, maybe master.
Lordship.
Because we are interpreting the word under this act,
Public employment.
public employment.
Lordship.
So public employment will mean a contractual employee or whatsoever. If it is he is continuing, it will be in public employment.
Lordship.
Moment it is in public employment,
Lordship.
any person will be entitled for, if he qualifies, suppose his period is small after regularization, he is not entitled for pension, then you have to count it from the date, initial date, because we are holding it that this is in public employment.
Lordship.
It will have an impact upon the state.
Lordship. So far as we are guided by the OM, Your Lordship, I don't think it will happen. Lordship.
Sure,
Lordship.
we'll record that.
Lordship.
Okay.
But if Your Lordship is of the view that that has to be clarified again, then
Why
Your
should we
Lordship-
clarify? We'll held whatever is the law.
No, because
We cannot have both. You cannot have both.
as per this OM, Your Lordship.
We understand.
Yes.
OM is not an issue.
Lordship.
OM is continuation. Okay. As per the OM, it is said that it should be continuation.
Yes.
And it will mean and public employment with continuation.
Lordship.
So public employment is a public employment.
Lordship.
Maybe for the purpose of this act,
Lordship.
maybe for the purpose of some other act.
Lordship.
For purpose of this act is that a person should not continue beyond 60 years or maximum 35 years.
Lordship.
This is the purpose.
Yes.
For that, we are determining a principle, what should be the date of public employment. The date of regularization may be public employment. Okay. The date of direct recruitment may be public. So far relating to those cases where there is a ad hoc or something like that, regularization will be the date with continuous service. So public employment is defined in this act.
Yes, Your Lordship.
So if that is the public employment, if we held that if there is, even if there is break and it is continuation, it will be a public employment in terms of the notification and this act.
So far as this
We'll
case
have to
is
decide. We cannot
Yes,
simply
yes,
say
Your Lordship.
on this fact. We'll have
That's
to
true.
give our reason
Yes, Your
that this is why we hold it to be a public employment.
Lordship.
Moment we hold it to be a public employment, that will have a far-reaching consequences upon the definition of public employment.
Lordship. So, Your Lordship, at para 6, Your Lordship.
Para
Para
6 of
6
the,
of the OM dated 29 March 2017.
okay.
Yes.
Mm.
Para 6.
Mm.
Now, therefore, it has decided that a period of service rendered on ad hoc contract were charged substitute period, which is followed by regularization or regular appointment without break or gap in service, except resignation, but notwithstanding the cases of resignations taken up with proper permission for another appointment, shall be treated as public employment, Your Lordship, and included in calculation of length of service for the purpose of pension under the Nagaland Retirement from Public Employment Second
Very
Amendment.
good, that is fine.
So, Your Lordship.
So we'll
Here-
hold it.
Yes, Your Lordship.
Then in every cases, for the purpose where there is no dispute as regards 60 years or 35 years,
Lordship.
assume a case where there is no dispute as regards it is 35 years or 60 years.
Lordship.
But dispute is whether he is having the qualifying service.
Lordship.
Suppose in a given case, what is the qualifying service for pension? This is for the purpose of retirement, 35 years.
Yes,
Say
yes,
suppose 20 years is qualifying service.
Lordship.
Now a person claims that my 20 years should be counted from my original, though there is a break, but I am getting salaries. So I am entitled for pension.
Lordship.
So what we'll say? We'll say even if there is a gap in the order, since person is in continuous, your argument is this, since the person is continuous service, which is fortified by payment of salary, therefore he is in a continuous service. So in any case, if we uphold, in any case, forget about this 35, 60 years,
Lordship. Yes.
any break, you will have to give pension.
Lordship, as per CCS rule, it's 10 years, Your Lordship.
10 years, so
Yes.
in 10 years,
Yes.
in a
The
given
case-
case, even in a given case, suppose a person is having break, he is not having continuous service, but he is getting salary. You will have to give him pension. Think over it. We have time.
Lordship,
Think over it. You are fighting with an individual.
Lordship,
But
Lordship, that I understand.
We have no problem.
Yes, yes,
Ah.
yes. Lordship.
If we held at all that this is a continuation of service for the reason that two count, your argument is in two count. Second order, all the orders where there is a break is in continuation of earlier order.
Yes, yes, yes.
And that it is in continuation, not only the record says, but during that period he continued to serve and salaries were paid.
Yes.
So therefore it was a continuation.
Yes.
So it cannot be deducted. This is your case.
Yes, Lordship.
This is her case. What is answer to that from your side?
Your Lordship, there is a 17 November order, the continuation, which the government is relying on. This
See,
in continuation of the department's page 28 of the writ petition, Your Lordship.
1989.
17 November.
Page
28 of the writ petition.
Page 24 is your first.
Yeah, first appointment.
First, which was issued on 2nd of August 1980. Second or
Yes.
first, either way.
Yes.
Okay.
There's
For 4 months.
yes.
After expiry of 4 months, Another order was passed on 26th of September.
Yes, Your Lordship.
After expiry of 4 months.
Admitted, Your Lordship.
So therefore, your contention is that there is a break. So, so your service should be counted from 26th of September 89.
No, the break is in the next extension order, Your Lordship, page number 28.
Page number?
28, the type copy.
Okay.
In continuation of, allow me to read, Your Lordship.
Mm.
In continuation of this department's order, even number dated 26 November 1989, the appointment of Sri Surjit LD Kam, typist in the office of the Advocate General Nagaland Gauhati High Court is hereby extended on the
No,
same
from
until further-
according to you, you are entitled, your services should be counted from 17th of November 89, isn't it?
Yes, Your Lordship.
This is your case.
Yes,
Because from here, there is no break.
yes, Your Lordship.
Break was in terms of order dated 26th of September.
Yes, Your Lordship.
Isn't it?
Yes, Your
That is what I am saying.
Yes.
According to you, the order ought to have been issued when?
When I was still in service.
28th of September 88, isn't it?
Yes, Your Lordship.
October.
Yes, Lord.
28th of October 80. But that is there. Huh?
Petitioner is confused.
Yes, it starts from 26, Your Lordship. It's a continuation of the depart page number 26. The order is 26.
24. See, understand.
Yes.
Then also it is continuation, isn't it? Before your expiry, that order has been issued. See, you just go through your first order at page 24. Okay, this is admittedly the first appointment.
Yes, Lord.
Now it says for 4 months.
Yes, Lord.
With effect from 28th of June 1988.
Yes, Lord.
When this four month will expire?
Your Lordship,
October.
if
It's a backdated order, Your Lordship.
No, it's a backdated order of
So-
2nd of August.
My appointment should be effected from, although it was issued in the month of August. My appointment should be effected from
20th of
June. Yes.
Therefore, from 28th of June, it should be 4 months.
Yes, Lord.
Then it is October.
Yes, Lord.
Your Lordship, if Your Lordship may see the para 3 of the initial appointment order, the appointment is purely on temporary basis and may be terminated by giving 1 month's notice till the post is filled on regular basis, Your Lordship. So there is no specific month mentioned here.
No,
regarding
yes,
the next
mention,
extension.
let's go to the first line.
Lordship,
Sri Surjit Singh is temporarily appointed on contract basis for 4 months
Yes, from time to time.
in this
Lordship.
office. Page 24.
Yes, then Your Lordship, this order is different again, Your Lordship, my copy. If Your Lordship will kindly see, this is the age.
Page 24. Kohima does.
Oh, yes.
Huh?
Lordship, this I have opened. Yes,
Isn't it?
Yes, basis for 4
So,
months, yes.
for 4 months.
Yes, Your Lordship.
Then you come to last paragraph with effect from 26, 28. Okay?
Yes,
Meaning
yes.
thereby on 28th of June he was
June.
actually appointed.
Yes.
But no order was issued.
No order was issued.
Therefore, on 2nd of August or 1st of August 88, an order was issued saying that for 4 months with effect from that earlier date.
Yes.
28th of June 88.
Yes.
Now,
Yes.
when 28th of June 88, 4 months will over, June, July, August, September, October.
Yes,
So,
Your Lordship.
28th of October, it will be over.
Yes.
Now, next order is
Next
issued prior to expiry on 26th.
Yes.
So, 26th.
Yes.
Yes.
26 issued till 31/10.
Yes.
Okay.
Yes.
So, till 31/10/89, it was extended.
Extended, yes.
Now, on 31/10/89, there was no order. This is his case.
Yes.
Isn't it?
Yes.
On 31/10, there was no order and it was issued only on 17th of November.
Yes.
So
the
there-
order
Order was on 17th of
Yes.
November.
But Your Lordship may see the content of the order in continuation to this department order of even number dated 26 September 89, Your Lordship. It is in continuation of the
Now, where is your
second-
statement that he got his salaries and all during this period?
Your Lordship, regarding the salary and those things, we haven't make any mentioned in our affidavit, Your Lordship. But Your Lordship, that is undisputed, Your Lordship.
Where is saying undisputed?
Regarding the salary, we have not mentioned in our affidavit, Your Lordship. His salary.
And what is his then? What is your affidavit stand in the affidavit?
Your Lordship, in our affidavit.
Now, how do you respond to that in continuation?
In continuation, Your
You
Lordship.
dispute that there was a break in service.
Yes, Lordship.
Huh?
Yes.
Break in service in terms of this order or actual break in service?
Actual break in service, Your Lordship.
Where have you stated? Tell us. Let us see your pleading in the writ petition. Now we understand.
If Your Lordship, mechanic rely on the affidavit in reply, Your Lordship. I've made a pure chart, a clear chart of my statements.
Just let us see your first list. Where is your statement regarding? Your stand is something different. At paragraph 3, the petitioner's appointment was further extended from time to time by issuing separate extension order during his service career. Last extension order was passed on 17/11/89, stating that the service of the petitioner is extended on the same terms and conditions till further orders. So you are in continuous service according to your pleading. Others are all officiating promotion, this, that we
Yes,
are not
Lord.
concerned with all that. Here issue is something different. Filing a writ petition or for determination is not relevant. Though you want to say that as a punishment they have taken it, but Okay, then what is your affidavit you wanted to stress? Reply affidavit,
Page 3, Your Lordship.
page 3.
Yes. There is a chart, Your Lordship, which explains my entire sequence in my service career, Your Lordship, along with my orders. I'm concerned with the page 4, that is the serial number 4, Your Lordship. On the right side, the remarks are orders passed on 26/9/1988, saying that this is in continuation of the order passed on 1/9/1989. Whereas there is no order dated 1/9/1989 in the existence regarding this order. There is no mentioning in the service book or in the note sheet of the personal file of the petitioner. This particular record is not available.
In this is annexer, order dated 26/9/1989. Annexer.
Annexer B, Your Lordship, page 26.
Annexer
B, page 26 of the writ petition.
Page 26.
Yes.
This is 1989.
Yes. This particular document will be pertinent to decide whether there is continuity in my service or not, Your Lordship. Whereas the government has not produced this particular document.
Yes, madam. What do you say as regards this?
Regarding this, it will be in his personal file, Your Lordship. So,
You have also not filed reply to this.
reply copy, I don't have the reply copy with me. It was not served to me.
Then we have
The
wasted time.
Lordship.
You will have to give a reply to this.
Your Lordship, record may be called.
Okay.
If this has to be seen, but
Hmm.
I don't know how it or from where the petitioner came to know
Heard
that.
Mr. Jamir, Larnet Senior Counsel. Full stop. Also heard Madam
Esmere.
Mary, Larnet Counsel. The issues involved in this writ petition is as regards the alleged premature superannuation of the petitioner. Full stop. According to the state respondents, the petitioner has, according to the state respondents, the petitioner served the state respondent on giving service of 35 years with effect from his initial date of appointment on 2/8/19 on
26, that effective date is
on
26.
26/8/1988. The petitioner was asked to go on superannuation in terms of the provision of Nagaland Retirement from Public Employment Act 1991, read with office memorandum dated 29th of March 2017. Inasmuch as it is the case of the state respondent that there has been a continuous service, the petitioner had continuously served the department with effect from 26/80/80 till his 1988 till his regularization on what was the date?
3/3/1993.
3/3/1993. Full stop. The contention of the petitioner is that the public employment of the petitioner is to be counted with effect from 17/11 17/11
89.
uh,
89. 89.
89 17/11/1889 for the reason that the last extension prior to 89 17/11/89 for the reason that last extension without any break was given to the petitioner on the said date on the said date the by filing this reply affidavit the petitioner has contended that as per Annexure B order dated 26/9/1899, though it was stated the petitioner service was extended in terms of earlier order dated 1/9/1989. However, no such order is existent, and therefore there was a break in service prior to 17th November 89. Full stop. At this stage, the Learned State Council has submitted that a copy of the reply affidavit has not been served upon the state. Accordingly, a copy may be granted as furnished to her so that the state can respond to such statement, which is an additional fact brought pleaded in the writ petition. That's why they will get a chance, because it is not pleaded in the this is an additional fact. No main writ petition, additional fact. Full stop. For the proper appreciation, the record also be kept ready. Personal service record of the petitioner shall also be kept ready on the next date fixed. Inasmuch as the issue revolves around whether there was any break in service of the petitioner prior to 17/11/1989, or the petitioner continued to serve the department, continued to serve the state with effect from his initial date of appointment on 20/06/1988. This is the issue?
Yes, Your Lordship, the respondents may be directed to place this record, the order dated 1/9/1989.
So that's why
That-
it will be, yes.
That's what I have said.
Yes.
Record should be.
Yes.
If that is there, that clinches now. Okay. List this matter when?
The 3 weeks, Your Lordship.
List this matter after 3 weeks.
For hearing, item number 31.
Yes, what is this IA?
Your Lordship,
What is this IA is filed for?
the petitioners have filed their argument.
For? Yes, what is this IA?
I have prayed for staying the recruitment.
Staying the
recruitment, Lordship, in the color
recruitment of what?
drivers, Lordship.
Drivers. Why?
Lordship, because it will frustrate. If recruitment process is initiated, Lordship, during the pendency of this case, it will frustrate the writ petition, Lordship. My prayers.
What is your prayer in the writ petition?
Now, there is a standing office memorandum, Lordship, issued by the government of Nagaland, under which in 2004, 50% of the recolor vacancies was to be reserved for regularization, Lordship. And
Now
in
what, let
2000
us see the prayer in the writ petition.
and in 2015, it was enhanced to 67%.
Hmm.
Now my only prayer,
Look,
Lordship,
who are you?
I'm a driver, Lordship.
You are a driver casual or what?
Ad hoc and temporary. Two are ad hoc and two are temporary.
You are still working.
Yes, Lordship. Petitioner number 1 was appointed in 2005, and the petitioner number 2 in 2008, number 3 in 2011, and number 4 in
Now, what is
2013.
your prayer in the writ
My
petition?
prayer, Lordship, is I may be allowed to read it out.
Yes.
At page 6.
Yes.
Therefore, in the premises aforesaid, the petitioner most humbly.
How many posts are advertised?
No, Lordship.
Huh?
Uh,
That advertisement you say want to stay, how
yes.
many posts are advertised?
That recruitment process has already been completed, Lordship.
Completed.
Yes, Lordship.
Now somebody is appointed.
Yes, Lordship.
Then what will you stay?
No, that is why, Lordship, I am not pressing for the IA at this
Okay.
stage.
Okay. Now somebody is appointed.
Yes, Lordship.
Now what is to be done today?
Now, Lordship, there is a standing office memorandum. My prayer is only that for future vacancies, Lordship, recruitment may be conducted as per the policy issued by the state government, Lordship.
Where is that policy? It is part of affidavit. What is the stand of the government?
Your Lordship,
That is office memorandum dated 17 March 2015.
Yes, Lordship.
Scheme for regulation, absorption of work sergeant, casual
Yes,
employees and
Lordship.
revision of pay.
Yes, Lordship.
That is.
Yes.
Your Lordship. Your Lordship, at the moment, none of the petitioners, they fulfill the criteria as laid down in the OM. So
What are the criteria?
they should have served for 30 years, minimum 30 years, having scale pay. But Your Lordship, the petitioners are in service for, petitioner number 1 has been in service for 18 years, the second petitioner for 15, the third petitioner for 12 years, and the fourth petitioner for 10 years only. So none of them, at the moment, none of them qualify. Once they qualify, then their services will be regularized, Your Lordship. But at the moment, it is not possible because...
Lordship, there are two manners in which regularization can be done as per this office memorandum.
One is that qualifying
Yes,
service.
yes.
And other is through the selection process.
Not selection process. The future vacancies, Lordship, are in the recolor capacity, Lordship. That 67% is to be reserved for the
for do people like you?
Yes, Lordship. Yes.
Why are you apprehending that they will not keep it fill up?
Because, Lordship, they, in fact, Lordship, that thing has already been blatantly done, Lordship, rampantly done. And see, Lordship, I am a direct driver. Now, there are so many drivers, Lordship, who are similarly situated, and we are working together in the same office, Lordship. Now, if I challenge my friend's regularization, Lordship, it does not create a happy environment within the office, Lordship.
No, that we understand. But see, happiness in when you are in a courts of law,
yes.
Happiness is not the issue. Issue is the right.
Yes, Lordship.
Issue is the right.
Yes. Now, they have not been regularizing me, Lordship.
No, they are, according to them, they said you are working.
Yes.
In whenever you will become eligible, we'll consider your case. That is their case.
Yes, Lordship. Now they are saying after 30 years, Lordship. Now, here, as per this moment, the department is misconceiving, is misinterpreting the office memorandum, Lordship. There are two manners in which regularization can be done. One is 30 years. The second is, Lordship, all future vacancies. All future, that is the word used, all.
Future vacancies what?
67% is to be reserved for regularization for people like me, Lordship.
So,
yes.
they will reserve it. Where is...
No, they are not reserving it, Lordship. That is
from where can you say it?
The fact
this is a, you may say that this is a fact. Where is your statement that they have already, because that, see, you are harping on page 17 plus 3.
Yes, Lordship.
The existing scheme of works as employees against normal vacancies being modified and the quota for works as employees stand enhanced from 50 to 67%.
Yes.
Your Lordship, this clause has expired. If you continue to read
this for next 5 years,
yes,
it will be 1/2015.
Yes.
Because this was done as a one-time measurement. See, regularization is as such is not a right.
Lordship,
Regularization is not a right, but whatsoever, In state of Nagaland, they are taking some schemes for regularization when scale of pay.
No, Lordship. Now, Lordship, they are saying they are speaking about an existing policy. Lordship, if Lordship may kindly appreciate the last sentence. This existing scheme will also be applicable. No, Lordship, the existing scheme for regularization of work charge employees. Now, the existing scheme is 2004 scheme, Lordship. I may be allowed to place the 2004 scheme, Lordship. No, so for the next 5 years, 67% was to be reserved. And Lordship, after that, it will go back to 50%. Now, at this stage, Lordship, the 2004 office memorandum still survives, Lordship.
We let us accept that earmarked is 67%. Okay.
Yes.
So can we issue a direction that regularize you in terms of that? Because they will have to see there may be some other person senior to you within that 67%.
Yes, Lordship.
Is that it?
Yes, that is why, Lordship, as per seniority, as per the office memorandum, in future vacancies, I may be regularized. That is the only prayer, Lordship.
We say that
I'm not praying for regularization.
They will not object to your prayer.
Yes.
We can close it saying that his cases for regularization be considered in terms of the extent norms.
Yes, Lordship.
That's
yes,
all.
Yes, that's all, Lordship. That's all. Yes. That is
nothing more. That we can
nothing more.
dispose it of.
Yes, nothing more, Lordship. Nothing more.
Heard. Mr. Santingal, Learned Counsel for the petitioner, also heard.
Lordship, off the record, Lordship. The fact that I have been required to file the IA, Lordship, it shows that the office memorandum is not being followed, Lordship.
No, that we understand.
Yes.
See, when you seek a stay, you ought to have come first when the advertisement was issued.
Yes.
Okay. Then they could have clarified that no, these vacancies advertised are not included within that 67%. This is for the rest. Because we cannot stall any selection process.
Yes, Lordship.
There is two quotas.
Yes.
One is, suppose we are saying 60% for people like you,
Lordship.
40% for direct recruitment.
Yes.
So all the posts cannot be eaten up by the persons who entered into.
Lordship.
You are all backdoor.
Yes, I'm not claiming
you are all backdoor entrance.
Irregular. Yes, Lordship.
Is not it?
Yes, Lordship.
There is no selection, nothing.
Yes,
Somebody will like you, is a good driver, call him.
Yes, Lordship.
Now what will happen to the person who was roaming in the street?
Yes, Lordship.
That is the judgment of Uma Devi.
Yes,
that
Lordship.
no regulation. But
Yes.
forget about that. State of Mizoram, this Nagaland is having a policy decision.
Yes, Lordship.
Will provide that this is your grievance. She said that his cases will be considered in terms of this. There is everybody is equally being treated. Will record her submission, and in that view will dispose it of.
Lordship,
Then
Lordship.
his case be considered
Yes,
in
that
terms
is-
of office.
That is also my limited prayer in this
Okay,
petition,
heard.
Lordship.
Switch. The grievance of the present instant writ petition is filed with a prayer that the prayer that the petitioner a direction should be issued to regularize the temporary / ad hoc services of the petitioner as drivers against existing vacancies earmarked for regularization and in terms of office memorandum number AR-3/GEN/201/2009 dated 17/3/2015. 17/3/2015. Full stop. The Learned State Council has submitted that the state of Nagaland has taken certain policy decisions and schemes to regularize for regularization and absorption of workers and casual employees and for revision of pay and wages. And the state of Nagaland will strictly follow such office memorandum so far relating to the case of while considering the case of the petitioner also, and petitioner's case shall also be regularized within the parameters of the office memorandum dated 17th of March 2015 or any such policy decision that may be taken by the state of Nagaland.
Yes, Lordship. Lordship, including the
Any such
Yes,
state
Lordship.
can be taken up
2004 may be reflected in the order.
taken by Nagaland. In that view of the matter, has SAR taken some policy decision initially, an office memorandum dated 24th of May 2005 was issued.
Lordship, not 2005, 2004, the previous page, Lordship. Yes.
22nd of September 2004 was issued for regularization of service of works as employees. Subsequently,
Your Lordship, if I may, the petitioners are seeking regularization basing on the OMD.
2015, that is why you have
Yes.
recorded.
Nowhere did they mention
No,
about
no,
the
that's why I just recorded it. We are not saying. That we also recorded a statement that as per policy and extant norms holding the field. Full stop. In view of the aforesaid consensus, this writ petition stands disposed of, directing the state employer / state of Nagaland to the state of Nagaland to consider the case of the petitioners for regularization and absorption in terms of the extant policy of the state of Nagaland, as discussed here in above.
Deeply obliged.
Writ petition stands disposed of. IA, in view of the order passed in writ petition, IA stands disposed of. Hmm? 11:30 it's over.
Yes. Deeply obliged.
अपना नाम लिखना नहीं देता है। So 38, 27 plus 9. You are.
made in the line of 2023, that would precede the line of